Good afternoon, everyone. My name is Clifton Johnson. I'm the founder and the executive director of the Empower Series, as you may know. For those of you who do not know, the Empower Series is a 501c3 nonprofit organization, so we are able to do what we do based on your generous donations and the contributions of Comerica Bank. So I want to thank Comerica Bank for their longtime support through their Comerica Charitable Foundation, as well as A&E Media Group, and then your generous donations as well. So if you want to donate, you can also go to our website at www.empowerseries.com. And in the top left-hand corner, you can click Donate. You can also click RSVP to see what events are coming up. And then you can also give us your feedback and take a survey in the top right-hand corner. Also, I want to give you a quick calendar update. Tomorrow is going to be our first fun and fitness fundraiser event at Fitness 360. So come out. It's at 9 o'clock, 10 o'clock. There's free group classes. It's going to be a Pilates yoga mixture class at 9 o'clock in the morning. So if you're up that early, you can come out. At 10 o'clock, we're going to have a mixed cardio class. And it's going to be at Fitness 360, which is off Live Oak. Go to our website. You can see it, the further information there. But come, it's going to be fun. We're going to have some refreshments. You'll get to find out more about the Empower Series and the fitness center there as well. We'll have T-shirts with the Empower Series and this challenge that I'm going to announce. It's going to be the Ideas in Action Challenge for 30 days and then another 30 days going forward, so I'll talk to you more about that. I also have some extra copies of Wendy Ida's book that she was our speaker this month, so she's going to be, she's not here, but we have her book, so you can get some books, meet some good people, and start your fitness journey. So please come out tomorrow, and then also next month, just to let you guys know, it is Life Insurance Awareness Month. So our topics next month is going to be life insurance. We're going to be at the Highland Hills Library the third Saturday of the month, at the Meadows Conference Center the Friday before that third Saturday here in Dallas, in Houston on the second Saturday, the 14th of September. We're going to be at the Houston Area Urban League in the Palm Center. So come out, look at our website, get connected. There's a lot of other things going on, too, here in Dallas, but our topic today is going to be on estate planning and legal matters. We have our guest, Kenneth Walker. Kenneth Walker is a two-time Empower Series speaker. He came and spoke in 2016 and 2017. If you want to find him, just Google on our YouTube channel, Google Empower Series, Kenneth Walker, or Wills and Probate. He's a member of Dale Turner Legal Association. He's a long-established attorney in South Dallas. But he's going to be here speaking to us about the importance of legal matters, not only with estate planning, but also small businesses as well.
Yes.
So welcome, Kenneth.
Thank you. Thank you. I appreciate it. Thank you.
So we started off by making announcements. So the importance of what's going on here in the probate courts. I think in September, it was September 6th.
No, 10th.
Oh, 10th, at 6 p.m.
At 6 p.m., yes.
So something's happening. And tell us a little bit more about that.
Yes. We will be having our third annual probate judges panel. And as I was telling you, it's a historic moment in the Dallas County probate courts because for the first time in history, we have 3 African-American women occupying all 3 benches in the probate court. And that is very significant because when I first got to Dallas, there were no African-American judges that I'm aware of, I think, on any of the civil benches at that time. I came to Dallas in 1987.
Okay.
I think there were maybe a couple on the criminal courts. But the probate court was not very welcoming, let me put it, as an environment to a young African-American attorney. Mm-hmm. And this connects back to the history of the Dale Turner Legal Association, which is the Association of African-American Judges in Dallas County, because the name of the association, that name is historically significant. The first African-American attorney licensed to practice law in the Dallas area was attorney J.L. Turner. And believe it or not, he came here practicing in the areas of probate and real estate in the heart of Jim Crow segregation in the 1890s, I believe.
Wow, man.
And so I would love to bring him back to see in those courts where he was treated as a second-class citizen, even though he was an attorney. I'd love for him to see the legacy of 3 African-American women sitting on all the benches in the Dallas County Probate Court. So on September 10th at the Dallas Bar Association, we will be having our 3rd annual probate judges panel. And it's a question and answer session where the judges appear, and there's an interactive session with the judges and the audience. The audience is primarily lawyers interested in those areas of practice, but it's open to the public.
I was going to ask you, so the public, would you recommend the public attend?
We'd love to have as many guests as we can get. Yeah.
Okay, so great. So it's going to be September 10th at 6 p.m. At 6. And it's going to be where again?
It's going to be at the Dallas Bar Association, the Below Mansion on Ross Avenue.
On Ross Avenue, okay. And if they want to go to a website and find out more about that, would they go? What website would they go to?
They go to the J.L. Turner Legal Association website. Okay. Or if they have any particular questions, they can call me. My number is 214-339-1490, and my law firm is Walker & Chambers.
Okay, definitely. We'll get that information out to you guys again. But one of the things we got to realize is that we're all standing on the shoulders of people who've come before us.
Yes, we are.
And what you said with the 3 women African-American judges on the probate court today, they're taking another step on that ladder.
Oh, yes.
And the future generations are going to be standing on their shoulders. So I'm really proud to hear that. I plan on going. I'm going to put that in my calendar, so I encourage everybody to come as well.
Great.
And I know that one of the things that you talked about is, estate planning. A lot of people think that estate planning is for people who have a lot of wealth and things of that nature. But I like what you said in 2017 when we were having a lunch and learn. You said that everybody has an estate.
Yes.
Because what we all leave behind are the people and the relationships that are going to be impacted by us not being there.
Yes.
And that was a great opportunity where you talked about your philosophy and your approach to estate planning, and this your approach to law in and of itself, right?
Yes.
So you've been practicing law for how long?
I've been licensed to practice law since 1987.
Okay. Yeah. And like you said, you came to Dallas and around that same time period?
I came to Dallas straight out of law school.
Okay. Mm-hmm. And where did you go to law school?
I went to Harvard Law School.
Harvard Law School, straight to Dallas. And what brought you to Dallas?
A job.
Money, right?
That's right. I started my practice with the law firm of Haynes and Boone.
Okay.
Yeah, they recruited me right out of law school.
Okay.
Yes.
And now where are you from? Give me a little bit of background now.
I'm originally from Memphis, Tennessee.
Okay, from Memphis.
Yes.
And why did you pick Harvard Law School? Because Harvard, that's a tough school to get into. It's kind of a little bit tough, right?
A little bit. I was encouraged by my very, very good teachers and guidance counselors. I went to public school in Memphis, and I had excellent teachers, excellent guidance counselors, and they told me reach for the stars. I didn't even think that was a possibility just because of the money involved. But they told me, no, there's scholarships and things, go for it. And they just encouraged me to, reach for the stars. And so that's what I did.
Well, one of the things that I'm doing with the Empower series, I'm giving local people, a platform to tell their story. Because I believe that there are people watching you, and they don't know. They see that you've been a successful lawyer here in Dallas. You, an entrepreneur. We'll talk about your transition from the firm to you going out on your own, but they don't see the process of your success. They don't see the hard work that you put in, right? And you just didn't wake up and say, "Hey, man, it was smooth." It's not that way, right?
No.
So I'm giving you an opportunity to tell a little bit of your story, but I really like the idea of giving you a platform to share your story, because there's people out there that can be inspired, can be given hope, and get connected with you to help them take that next step to achieve their goal. Just like you were encouraged to go to think about Harvard and to apply and to make it, even though you didn't think that it was really possible. You thought there was some big hurdles for you to overcome.
Yeah, my story I don't think is so unusual. There are a lot of successful black people in all areas of life now. Okay, you know, I was born in 1960. Okay, and so I'm one of those people who came of age before Jim Crow ended, but I'm sorry, I was born before Jim Crow ended, but came of age after it ended.
Right.
And so, you know, doors were opening at the time to us. I grew up in Memphis, like I said, went to public school, grew up in a housing project, raised by my mother, primarily probably from about the age of 10 on, and very poor, but I've always loved learning. You know, Frederick Douglass has a great quote about learning to read. I don't remember the exact words, but reading, the power to read, the power to digest information liberates the mind. It allows you to think and imagine possibilities that are beyond your material circumstances. And I've always imagined beyond my material circumstances, but I've always been encouraged, you know, first and primarily by my mother. But I've had so many great teachers and mentors all my life. I mean, I've had people just pour good into me, you know, the good from them into me, and ask nothing of me except give back.
Yeah, and do your best, right?
That's it.
And don't quit. Don't quit.
Oh no, don't quit. Don't quit.
Don't quit.
No.
Well, man, that is good to hear. I was born right after you, right? 61 was my year.
Oh
man.
yeah. Oh yeah.
And so you went to Harvard. You came out of Harvard, and you came here, and you started working for a firm.
Yes, I did.
How long did you work for that firm before you stepped out on your own?
I worked for Haynes and Boone for a couple of years, and then I went to another big firm, Weil Gotshal in Manges, and I worked for them probably less than 2 years. And I left there, and I went to work for State Senator Royce West's firm at the time, Robinson and West. I stayed there for maybe 2 or 3 years. And after that point, I was ready to start my own law firm.
Okay, so we're going to talk about that, and then we'll get into your specific areas of law. Because a lot of times people are thinking, man, I need to be entrepreneur. I need to be entrepreneur. And what I hear is that when you come out of college, you don't necessarily know a lot. There's no problem going directly to entrepreneurship. But why not learn on somebody else's dime?
Oh,
right?
oh, by all means.
Why not learn while you're getting paid?
That's
why
right.
not make the mistakes?
Yeah.
So,
That's right. Get paid to learn.
Exactly. Yeah. So at this point, you were looking at starting your own firm. What prompted you to go ahead and step out on your own?
Oh, I knew from college, before I even went to law school, I wanted to own my own business, my own law firm, something. Okay, I wanted to own, because one of my mentors, a young preacher at the time, he drilled that into us. You know, we would talk about, you know, like young men do, you know, being athletes, you know. And he would say, don't be on the team, own the team. Gotcha. Own it. And so this concept of ownership of your own thing was just something that came naturally to me. And so I went into law in anticipation that I'll learn, I'll get trained on somebody else's dime. Right. And then I would start my own thing.
Okay. Now, what's your area of What's your area of specialty?
My area of practice, I concentrate and focus on representing small and mid-sized businesses. I wind up being the outside general counsel to small and mid-sized businesses. Now, it's not exclusively businesses because we represent plenty of individuals. We represent nonprofit organizations. But my focus is on business law, business transactions, business litigation, whether it's in real estate, corporate tax, banking, whatever is of a business nature for a business or an individual or a nonprofit, I'm there to serve.
So I'm curious about nonprofit now. My ears are perking up. So what do you do specifically for nonprofits, or the type of things that you would do for them, given your firm and their needs at that time?
We do everything from setup, organizing the initial nonprofit, getting them qualified for tax exempt status, all the way to when they've got major expansions going on, and let's deal with churches in particular. Churches constantly are expanding their facilities, their infrastructure. So we wind up doing a lot of construction law, a lot of real estate law in terms of land acquisitions and things of that nature. There are always contracts that nonprofits are engaged in. Nonprofits are engaged in business transactions. Their purpose is not to make a profit for their owners, but they are engaged in commercial and profitable activities. In order to be successful, so that they can use those resources and give back to their donor bases, or whatever their target market is. But they're very much businesses.
So there was a question asked by one of our viewers as to why we are asking for donations, because they didn't know that we were a nonprofit. And I had explained to them that we do make a profit, but that profit is really going towards the furthering of our mission.
Yes.
It's not distributed to, the owners. And first off, there are no owners there's no individual owners of a nonprofit organization. It's owned by the general public.
Yes.
It's just governed by a board of directors, and then me as executive director, I'm the employee doing the work.
That's right.
But people need to understand that a nonprofit does not mean that we don't make a profit. We need to make a profit to be sustainable.
Yes.
And so that's very important. So I see that. And so we'll be talking more about some of the expansion ideas that we have for the Empower series. And so that's one aspect. But then you also do estate planning.
Yes, I do. I do. And my focus initially with estate planning was on my business clients, because, business owners are trying to build wealth for themselves and their families. And the core of that wealth, is around business. And they're also trying to build legacies. And so how do you transition a business across generations? Well, you need estate planning and the tools that it gives you to be able to do so, But estate planning is not limited to businesses. As, we said earlier, everybody has an estate, You don't have to be rich to have an estate. All you have to do is die. And whatever it is you left behind, that is your estate in terms of the things. And then you've got those relationships, people that you care about. And you want to take the power that the law gives you to determine across the generations what happens to whatever it is that you valued during your lifetime that you'd like to see passed on beyond you. Otherwise, the state, in our case, the state of Texas, they write your will for you. It's called the Texas Estates Code. And it goes wherever.
It may not be what you want, right?
It may not be, and it may definitely not be who you want, So, you take some control and make that determination for yourself.
So that is an area that a lot of people are not familiar with, and either it's through just intentional avoidance or unintentional avoidance. The thing is, this October, we're going to have a workshop on estate planning.
Yes.
So that's going to be for the month of October. And specifically in our area, and I give you an update, the location is not going to be the Highland Hills Library. The Highland Hills Library is being used for some other purpose. I'm just now telling you that. So we'll identify a new location, but stay tuned. in October, what we were talking about doing is doing actually a will workshop. So it's not going to be a lecture, but it's going to be an opportunity for people to come in and take that step to get something done on a very simple basis, right?
Yes, okay. Yes. We'll actually have a clinic, and it'll be on a first come, first served basis. And for a certain period of time, we will have people there to create simple wills for the attendees on a first come, first served basis. And so you can walk away from that event with a simple will. And then after the clinic, then we will have a workshop about what a simple will gives you versus a comprehensive estate plan. And you can make an assessment as an attendee as to whether the simple will that you have is sufficient for your needs and your family's needs, or if you need to do something beyond that in terms of additional estate planning.
Okay, so we're going to stay on this topic because did you hear that? We're going to give you some information to prepare before the workshop because you do need to know certain things, like who do you want your executor to be, your beneficiaries, some information about them, so that you can walk into that clinic and actually have them have a document that is completed with that information. So we'll get that information to you. But what would you say, given your experience, are some of the things that some common misunderstandings about the basic estate planning process that people need to know that we need to clarify on this show?
Well, do we have enough time?
Well, we can start, right? And I'll cut you off.
Yeah.
But we got some time. Right?
So we'll just try to hit the high points. But let me make you aware of something that I think I may have mentioned to you before. I, as chairman of the J.L. Turner Legal Association's Estate Planning, Probate, Tax, and Real Estate section, we are compiling a white paper on, I put in quote, bad ideas about estate planning, common misconceptions about estate planning. And so we're compiling those, and we will be publishing that white paper at some point in the future. Okay. Because we want to educate the community about some of the misconceptions that are out there. And I guess some of the most common is I don't need a will at all because I don't have anything. Mm-hmm. Well, if you have lived in this world for any period of time as an adult, you have something, okay? It may not be much, but you have something. And that something can make the difference in a person's life, all right? My paternal grandfather had a, little small piece of land in Mississippi, a tiny little farm, okay? And after he died, my sister and I inherited that tiny little piece of land. Now, we weren't going to go and farm any land, but that tiny little piece of land happened to, my share of it happened to come to me at a time when my older daughter was first going into college, a very expensive private college. Mm-hmm. And that little tiny farm helped finance a significant part of her education at just the right moment. Mm-hmm. And so, he may not have thought about the importance of that, but she wound up getting, a top-notch education because of that little piece of land that he left. And so anything that you can leave to the next generation, it's very important. And the opposite is also true. The fact that you don't take the time to direct it to whomever you want it to go to means it does go to someone. Yeah. Okay? It doesn't vaporize. It goes to someone. Why not make it go, no matter how small, to someone you care about? So that's one thing, is, you have to be rich. No, you just have to be an adult who has lived for any period of time and accumulated anything big or small.
So let's talk about that.
Okay.
Let's look at a situation where someone really doesn't have much. So they don't have a home.
Yes.
They don't have a car.
Yes.
Okay, I'm going to do simple, right? They don't have a
Okay.
car. They're renting an apartment. They just got stuff in their apartment.
Yes.
Right? They're not married.
Yes.
So they pass away. Is there a difference between having a will and not having a will for that individual?
Well, let's look at what's in their apartment.
Okay.
Okay. There's furnishing, right? Mm-hmm. There's clothing. Mm-hmm. There may be jewelry, right? There may be collections of books, recordings.
And family's going to come in and just take.
Okay.
Right.
And
I'm setting you up for something, right?
Exactly. Okay. Now, this this is the type of stuff that you couldn't sell it for a lot of anything, but you could choose who gets what. Okay.
Right.
And even the memory of that can be extremely significant. Okay. Something that I have written that I pass on to the next generation may be significant. Pictures may be significant. You never know what will inspire people.
Right.
And that's the other thing that I think is a misconception about estate planning. It's not just about the money, okay? It is about the values that you live by that could actually live on if you took the time to pass it on through an estate plan.
Yeah, I love what you said about the fact that, my uncle passed away recently, and regardless of all of the stuff that he had, what really was impactful were the people's lives that were impacted by his passing, and taking the time to have an estate plan or a will to communicate something it's meaningful to a lot of the people who are left behind. And so I like what you said about that. So give me an example of this, though. Let's say someone has stuff in their apartment. They have a will. There's a cost to probate that will. People don't know that, right?
Yes.
So sometimes do you look at, is it worth the cost to probate a will versus just not having it be probated? What's your advice on that?
Yes. You do have to weigh the cost and the benefits. But that's why you need to plan in advance, okay? Because there's an alternative to probate by utilizing a trust, okay? So this person with just some things in their apartment could set up a trust during their lifetime, all right? And they could actually transfer title to those things into the trust. And if they're already in the trust, then if that's all that they care about, then there would be no need to probate the estate because all the assets are already in the trust. They were transferred to the trust before they died.
So understanding the difference between a will and a trust and how that works is what we're going to talk about. Just on another commercial, the Zan Wesley Holmes Outreach Center is having a workshop on wills, powers of attorney, and non-probatable assets. And that's going to be on August 29th from 11:30 to 1. It's going to be at the Fraser House, 4600 Spring Avenue, and it's going to be taught by an attorney, Stanley R. Mays. Do you know Stanley?
Not only do I know Stanley Mays very well,
okay,
but
give him a shout out, Stanley. What's up, man?
Yeah, hello, Stanley. When we were talking about nonprofits, one of my clients who is a nonprofit is the Zan Wesley Holmes Community Outreach Center. Okay. Yeah. So
yeah, so that's good. So
I know both.
Did you know about this workshop coming up?
No, I did not know.
Yeah. So you don't have to wait until October.
No.
You should come in October, but if you got some time, August 29th, the Fraser House, 11:30 to 1. It's going to be like a lunch and learn, but get as much information as you can.
Yeah.
Okay. And talking about a will and a trust, so a lot of people don't know what the difference is between the two. How would you describe the difference between I'll let you do the talking.
Okay.
But clarify that for people.
A will is to determine where your property goes after you die. All right?
Mm-hmm.
And so you do a will while you are alive, but it does not become effective until after you die. So if I say I'm giving this, house to my daughter, it doesn't become effective until after I die. All right. On the other hand, a trust, transfers to a trust can be made while you are alive, or they can be made after you are deceased. Mm-hmm. Okay? So with a trust, you can do both. Lifetime transfers of property and transfers of property after you're gone. And a trust and a will actually are complementary tools for an attorney, because what we will normally do for a lot of people, and again, it depends on the circumstances, we will set up a trust, okay, and we will transfer some things to the trust during the lifetime, and then anything that we didn't transfer during the lifetime, once the person dies, mm-hmm. the will comes behind the trust and scoops up everything else and pours it over into that trust. So the two are not alternatives. They're really complementary.
Okay. So, and we're going to talk about a way of a process, but before we even go there, let's define now a trust, because a trust can be looked at as, it's not a human being, but it is an entity that can have ownership of accounts, material possessions, and things of that nature. So how would you describe a trust to someone who doesn't know what a trust is?
A trust simply is transferring property to someone, the trustee, who will hold title to that property for the benefit of someone else, the beneficiary, okay? And so if I'm going to set up a trust for Clifton, okay, I've got these nice bottles of water. Okay. All right. Clifton's my beneficiary. So I want to make sure Clifton gets these bottles of water. But I don't want to put it in Clifton's hands, because Clifton may
drink all the
water. He may drink all the water.
Right.
And so I want him to hold on to this water, because it may be valuable down the line. Right. Okay. And so because Clifton, I don't want to put it in his hands directly right now, I may say, okay, Jose, he's a good trustee. I'll put the water into Jose's hands, and I will say, Jose, you hold on to these bottles of water, and at the appropriate time, based on my instructions, you give one at a time to Clifton, because I don't want him using up all the water at one time.
Okay.
That's the nature of a trust. There's me, the settler, the person who...
Or the grantor, right?
Or the grantor.
Okay.
The person who creates the trust.
Okay, so the person who creates the trust is called a grantor.
Grantor or settler.
Or settler, okay, got it.
Okay, so I create the trust, mm-hmm. and then I have a beneficiary in mind.
Which is me.
Which is Clifton.
Okay.
And then I have a trustee that I put over the property, okay, and he's holding that property for the benefit of the beneficiary.
And that's Jose.
That's Jose.
And he's called the trustee.
And he's called the trustee.
So what we realize, though, but it's not Jose's stuff, because it's owned by the trust. So even though Jose is the trustee, he doesn't own it. The trust owns it.
Yes.
So the trust is like this legal entity that has the ability to own stuff, whether it's a car, bottles of water, money, property, whatever that is. So it's a separate entity of which the three players, like you said, the grantor, the settler, which is the person that creates the trust, the beneficiary, which is me in this situation, or it could be your children or your relatives, whoever you want to give the money to, or the resources to, and then a responsible person,
yes.
which is the trustee, and
yes.
that trustee is responsible for following the details of your trust.
Yes.
That explains how you want that material to be managed, or they're responsible to managing it, making sure they follow the rules of the trust and everything of that nature.
For the beneficiary.
Yeah, and for this trustee who might be a relative or someone that you trust, they can work with an attorney or some other entity or legal person to make sure that they're doing the right things legally.
Yes.
Right.
Normally, the trustee will work very closely with an attorney because the way the trust is created is by what's called a trust agreement. Okay, and that's where the person who creates the trust spells out the duties and responsibilities of the trustee and the rights of the beneficiary. And that's a legal document that has to be created, and it has to be interpreted by the trustee with the assistance of an attorney.
So what's really important, and we can only go so far, like you said, there's only so much time, but to determine whether a will or a trust is appropriate, you really need to sit down with an attorney and talk to them about your situation. And everybody thinks their stuff is simple, though. Everybody thinks it's simple.
Everybody does.
Yeah, but I would say having a simple will is the basis, but it may not be what you really need if you sit down with an attorney and really talk about your wishes, what you would like to have happen. Then that attorney can advise you on what is the best strategy to ensure that your assets are transferred, efficiently to other people. And it's an emotional time. So people are going to be, high emotions. I don't care, even if you have a will and a trust, emotions are going to be there. And a lot of times when people sit down and they get their estate plan in order, they feel like it's done. They check the box and they move on. But we had talked about the fact that very rarely do people go through this process. So it's very important after you get everything done that you get everybody around the table and you sit down, and even with the attorney, to say, okay, look, let's play out this scenario. If something was to happen and I didn't wake up tomorrow, these are the first things that should be done, and these are some things that shouldn't be done. So in addition to the fact that no matter what you have, you do really need to sit down and talk about some estate planning with the will. What are some of the other common mistakes or things that you feel are important for people to know that they don't know?
Well, take spouses. Okay. A lot of times people think that spouses have to do a will together, but especially in Texas, because it's community property. Well, no, that's not the case. Each spouse has the legal right to dispose of their share of the community property in any way that they choose. Okay, and so you literally could give your share to your girlfriend, okay, or your boyfriend, okay. Yeah. Dangerous.
Right. If you still live with your spouse,
to
right?
you and the boyfriend or girlfriend, okay. So not advisable,
right.
But legally, theoretically possible. But yeah, so there's this misconception that husbands and wives have to, kind of do a joint plan, but they don't. Okay, they commonly do, and many times it's very good for them to coordinate for lots of reasons. But sometimes you have one spouse or the other spouse who comes in and says, I want to do an estate plan for myself and my spouse without the spouse. Okay,
you can't do that, right?
Oh, absolutely not. No. Both people have to be at the table, okay? Right. Otherwise, it's just yours, okay? It's not the other spouse's. No.
So just to clarify, when you look at the estate planning process, the basic documents is a will, last will and testament.
Yes.
You normally have a power of attorney, a durable power of attorney, medical power of attorney,
yes,
possibly a trust,
yes,
a physician directive, or what's called a living will.
Yes.
All we're doing in the workshop, though, is a will. We're not doing these other documents because they are separate documents.
Yes.
And you need to sit down. So when you think about this, the will, and what, as a financial advisor, when I sat in with my clients who were talking to the attorney, spouse, husband will have a set of documents, the wife will have a set of documents. So even if you're working together and you're planning together, you still have separate documents.
Oh, absolutely.
Right? So you can't have one will for both the husband and the wife. You have to have two. I'm understanding you have 2 wills and you can coordinate with them, right?
Well, actually, there is something called a joint will.
Oh, okay, cool.
Okay, but it's a rare thing. Okay, and it should only be used in special circumstances. Okay, and never without an attorney to tell you when is appropriate.
Okay.
But under normal circumstances, all the estate planning documents are separate.
Okay, that's all I've seen. So.
Yeah.
I'm in a normal situation.
Under normal circumstances. But that's the importance of consulting with an expert, because you don't know what tool is appropriate for your situation.
Right.
You know, it's like prescribing medication, okay? I may think I know what's wrong with me, okay? And I can go to any drugstore and buy anything off the shelf. But if I have misdiagnosed it, then the stuff off the shelf, one won't work. May make things worse. And so I need to go to the medical expert, get a diagnosis, and then what may work may be only something that he can prescribe. Mm-hmm. It's the same with legal matters. You need to at least consult with the expert, get a diagnosis, and then get a legal recommendation as to what is required. And, you know, good lawyers will tell you these things you can do on yourself, do yourself and save you some money, okay? Right. These other things, yes, you will require a lawyer to do these things, okay? But at least get the legal consultation, the diagnosis, so that you know what it is you need and who's best able to provide that.
So are there some attorneys that give free consultations? Because sometimes, you know, time is time. And some attorneys may charge $250 or some amount for either 30 or an hour meeting. But are there some attorneys that will sit down with you for a brief period of time just without any cost, or do you not see that?
No, you see all the commercials of free consultation, okay? And there are lots of attorneys who do free consultations. Mainly the free consultations are for personal injury attorneys, okay? And they have a whole different fee structure, all right? For attorneys like me, we charge a consultation fee, okay? We charge $225 for a consultation, all right? But you're going to wind up getting more than $225 of value out of that consultation, because my hourly rate is $300. Two, I'm going to ask you, give me all the information required for your situation in advance. I'm going to spend time reviewing it in advance, and then I'm going to come to the consultation really prepared to talk to you in detail about the issues that I see and what I recommend. And, you know, we may spend an hour in that meeting, but the preparation time can be an hour, 2 hours. I mean, I've spent 6 or 7 hours sometimes just preparing for a consultation.
Right. So one of the things I like is that you are very involved. You and your partner, who's in Houston, are very involved in the community, hence what you do with the Jail Turner Legal Association, what you're doing with the Empower Series. We find that around over 65% of my attendees and the people who are following me are low to moderate income individuals. And with that being said, that $250 is hard to come by. How do you address the true cost of getting this stuff done? Are there other ways of, you hear about people just put on a piece of paper and sign it, or are there other ways of doing it that is legal and just as binding without having to come up with money to get this stuff done?
Well, this is part of the problems with living in a market-driven capitalist economy, right? There are real financial barriers to what you have a right to, right? It's just like with the medical profession, right? There are lots of people who need serious medical help, and they don't have access to health care, you know, or really good health care. And so they wind up either doing without, self-medicating, or accessing whatever is publicly available. Well, the legal profession is even worse in that regard. because there's no such thing as, a legal hospital. Now, there are legal service, legal aid, and there are attorneys who do pro bono work, okay? But there's no centralized mechanism for, poor people. And so part of our mission as the Jail Attorney Legal Association is to try to reach out to the lower income sectors of our community, one, to provide the best possible information through, these clinics and workshops, and two, to give them self-help tools when they can't afford to access an attorney. And then three, we also, on a case-by-case basis, will provide pro bono services.
So definitely take advantage of this work clinic that we're going to do in October. Take advantage of this workshop that's at the Frazier's house. Connect. Contact me, thrive@empowerseries.com. If you have questions, I would direct you to a resource that can help. Because I think it's important. One of the things that we do, in addition to giving hope and inspiration, is we educate. Educate and connecting people to resources that they don't know is around them, so that they're not making poor choices and decisions. But it still comes back to where if you don't have money, the options are limited. There's not a lot of free choices out there. You got to be careful what you get, because you get what you pay for. So you would still recommend for a family that is low to moderate income to at least find an attorney to sit down with and talk about their case.
Yes.
And definitely take advantage of the Empower Series, what we're doing. Do you guys do any other clinics or things of that nature where people can come, or do you have anything on the calendar in addition to this this event coming up on the 10th of September?
The judges panel. And then, we've got the clinic with you in October. We don't have anything else on the calendar right now. But one of the things that we do is we make ourselves available to nonprofit organizations, churches in particular. And so if someone wants a clinic on a legal topic, okay, and we can schedule it at a time that's mutually convenient, then we'll make ourselves available. We just finished an estate planning and trust. No, it was broader. A legal clinic on various topics for the Delta sorority at the Thurgood Marshall Community Center off of Hampton. And so if there are groups out there who want us to show up,
reach out to you.
Yeah.
Okay, I got two questions from someone who's watching.
Okay.
And there's two related questions. I'm going to ask them both.
Okay.
And you address them both. One is, what about power of attorney? So we talked about a will, we talked about a trust. So, define a power of attorney. Then the second question is this: what if there is only one child and other family members challenge kid for property?
Okay.
All right. So talk about those two things.
Okay. Let's talk about powers of attorney, because in addition to the wills and trust and those things that are basically talking about transferring property either during lifetime or after lifetime, you've got to have an entirely different set of tools to deal with disability and end of life before death. Okay, because for most people, before they die, they're going to age, and they are likely to have deteriorating health. Okay, and so you're more likely to encounter first mental and physical decline and ultimate disability before you even have to deal with death. And so wills and trusts are not sufficient to deal with that, because now you're talking about medical decisions that have to be made, as well as business decisions that have to be made. Somebody has to care for the person, and somebody has to care for their property.
And their finances. Just not keeping up with the bills, right?
Yes. And so a power of attorney is one tool, but only one tool. Misconception, people will think that a power of attorney by itself, gives you the ability to handle everything you need to for a person who can't, do for themselves. But it doesn't. It's one tool, and it's a limited tool, okay? number one, it goes into effect only when the person is mentally or physically disabled. And so if somebody if I give you a power of attorney now on behalf of myself, all right, that doesn't mean Clifton can get up today and go take over my finances and make my health care decisions.
Unless it's immediate, right? It's called spring forward and immediate. There's two ways, right?
But for most powers of attorney that we're talking about, they only take effect
if I don't have my right frame of mind.
If you are mentally or physically incapacitated, as long as a person can, take care of their own affairs, that power of attorney doesn't mean anything.
Now, USAA has a power of attorney, and some financial services have power of attorney documents that are immediate.
Yes.
But the one that you go to an attorney with, you do have to state there whether it's, like you said, only when you get a doctor's notice that I'm not of my right mind.
Yes.
Because when you make it immediate, that's like you really got to trust that person.
Yes, but even if I make it immediate, okay, even if I say, right now, Clifton has, total power over my financial affairs, all right? I can take that back. I can revoke that anytime I choose, all right? And so a big misconception about powers of attorney is that some way you now are in control of that person. You're not.
Make decisions, yeah.
No, because people will use the phrase, I have a power of attorney on somebody, as if they have magically seized control of another human being, okay? We got past that with the 13th Amendment, okay? You don't own other people through a power of attorney.
So another good reason why it's important to sit down with an attorney and talk about that. So it's a document that does give you some control to make decisions as an agent of an individual.
Yes.
But that person still has the right to make the decision on their own. And you got to look at the details because it's limiting.
Yes,
it's not
and then
overall.
It ends at death.
Right. And that's another thing people don't know, right?
Right.
So when someone passes away, that power of attorney is null and void.
It's dead, okay? Because people will assume because I had a power of attorney during a lifetime, now I have the power of attorney after death, and so I can take care of their estate. No, it died.
And so sometimes people confuse the power of attorney with the executor. So like you said, the power of attorney is a separate document.
Yes.
It ends when a person passes away.
Yes.
And the will takes over then. And then it's usually the executor or some other term based on, the status. Okay, so that's the power of attorney. But then how do you deal with now if you have one child and for some reason the other family members are now challenging that child? That was the question that a viewer had.
Okay. Any human being can designate anyone else as their beneficiary. And so the fact that I have more than one child does not mandate me to designate both children as my beneficiaries. I can designate one or the other. I don't even have to designate either one. I could designate anybody else in the world that I choose, okay? And so whoever I designated as my beneficiary, that's what controls if that's what's in my will, all right? And if the other child is left out of my will, yes, they could try to challenge my will, but as long as I had legal capacity at the time I made that will, and there's no fraud or undue influence involved or, those types of things, then if I chose to favor one child over another, that's my right. And the child who tries to challenge that will lose that will contest.
And I've seen some cases where there's a clause in the will that says if anybody challenges my will, then they are cut out completely.
Yes.
Right. So this is another example where it's very important to make sure that you're getting competent advice from an attorney to do a will, so that it hopefully lessens squabbles like this.
Yes.
And in cases where there are fighting, it may come out as a result of there's not really a clear or executable will or something of that nature. I don't know what the terms are.
Most of the fighting probably occurs because people didn't leave a will at all. Yeah. Okay? And it really gets intense when you have blended families. right? So if you have someone who's been married more than once, if you have someone who has children by more than one person, all right, you're leaving behind, especially in the absence of a will, a lot of fighting that can take place, because just determining, first of all, paternity, okay, who is actually a biological child, who wasn't actually a legally adopted child, all of those things come into play just with a blended family without a will, okay? But even with a will, if you are not clear as to who your beneficiaries are, because suppose I leave a will and I say, all my children, I leave everything to all my children. Well, what does all my children mean in the context of a blended family and adopted people?
Like the ones you claiming?
You're right. And then there's some that you actually treated as children and some you didn't. What the heck does that mean, right? So you have to be precise in who your beneficiaries actually are, even when you leave a will. Otherwise, there's a lot of ambiguity, and ambiguity always creates room for attorneys to fight about.
So it comes back to where you think you got a simple will, right?
Yes.
I mean, even in families that are like tight knit families, it's crazy how the passing away can create, evoke true colors in people.
Yes.
And so I would say that if you really care about the relationships that you're leaving behind,
yes,
it's really important to go back and make those decisions to identify what it is you want. And,
yes.
And the other misconception is that attorneys cannot make decisions for you.
Oh, no.
You've got to make the decision, because someone may come to you, and if they haven't decided who's going to do what, you can't magically tell them what to do. You can, if they come to you, they have to know what it is they want, and then you will show them the legal way and the documents that are required to facilitate what their wishes are. Is that correct?
Exactly.
Okay, and Alzheimer. Well, yeah. Answer that question.
Yeah. The client sets the goal. What is the ultimate goal? Mm-hmm. All right, and then the lawyer tells you what options you have for reaching that goal, and the pros and cons of the various options. But we have now a concept in my office of know your family, okay? Because when you come to me as a client, I don't know you a lot of times, and I definitely don't know your family. And what I mean is the full scope of your family situation.
Yeah.
So you need to be honest with me, and everything you say to me is privileged and confidential. It's just between us. But you need to be as honest with me as you are with your doctor. Hey, Mr. Lawyer, these are my family dynamics, okay? And just because you want a simple will doesn't mean that's what you need, because if you got a complicated family situation,
you got some crazy family.
Okay. Oh, heck yeah. Okay.
We all do.
Then a simple will is not going to get you what you need.
And here's the other thing, though, because at some point, we are at some point going to lose our mental capacity.
Yes.
Right. Alzheimer's or Parkinson's, whatever it is, and we can't care for ourselves. It is so important for us to sit down with an attorney and lay out these decisions as to who do we want to speak on our behalf before we start losing it.
Yes.
Because after we lose it,
yes,
then it's going to be even tough, because you got to have a court involved to assign an agent in that matter,
guardian,
right? Or a guardian.
Yeah.
So
well, here's a big misconception. Okay, legally, especially when it comes to the terms like Alzheimer's. Okay, legally, you only have to have mental and physical capacity at the moment you sign the will, okay? And so you can be completely incapacitated before you got to my office, and completely incapacitated after you left my office. But if you have full capacity while you're sitting there at my office in front of witnesses, two witnesses, okay, then you have signed a perfectly valid will. And so when people say, oh, my relative has Alzheimer's, well, there's so many different levels medically and so many different stages that at certain points in time, in the legal world, they call them lucid moments. Mm-hmm. A person may have lucid moments or lucid periods of time where they're perfectly capable of signing a legally valid will. So just the fact that somebody has been diagnosed or suspected, okay, or have some memory loss doesn't mean that they can't make a will.
Man, I'll tell you this. We can go deep into this because we only scratched the surface when you think about it. We didn't go deep into the other documents. We didn't go deep into trust or, a special needs trust for kids with, special needs. We didn't go deep into the different levels of powers of attorney or medical powers of attorney or the living will. We didn't do that, and entire time is kind of up. But I would say this, when I was looking at the comments from your Empower Series sessions, some people are looking for you, right? They were looking for you on LinkedIn. They couldn't find you, so I put your address and stuff in the comment. But if someone wants to follow up with you and get in touch with you, why don't you give them the best way of reaching you? Okay. Again.
My office telephone number is 214-339-1490.
Okay, one more time.
My office telephone number is 214-339-1490. Okay. And my email address is kw@walkerchambers.com. KW, as in Kenneth Walker, at walkerchambers.com. Chambers with an S, all one word.
Okay, and we didn't even get a chance to talk about business, so we may have to bring you back and talk about really diving into the business, sure. Your business clients, and one of the things I was just talking to a friend of mine who runs Goldman Sachs 10,000 Small Businesses. So I really want to talk to you about that program and other resources that are available for business owners, so that they can really put themselves in a position to utilize your services and continue to grow. So that's going to be our second appearance if you've got time for that.
Oh, sure.
I know that your time is precious. Okay.
We look forward to it.
And so again, mark your calendars in October. Contact Kenneth. He's a good resource. He's in the community. And where is your office? It's what city is it in?
My office is in Duncanville.
Okay.
Okay. 150 East Highway 67 in Duncanville, Suite 240.
Okay, and then your partner has an office in Houston as well.
And my partner has an office in Houston as well.
Okay, so if you got some people in Houston, or if you're watching in Houston,
yes.
You got an office out there. And
yes, yes. We practice all over the state of Texas.
Really, and also outside of Texas.
And we have clients from California to Florida. Okay. There are certain things that we can't do because we're only licensed in Texas. Okay. But there are other things that we can't do.
Okay.
Yeah.
Okay. Well, definitely, man. I want to thank you. You will be back. I want to thank all of you for watching and spending this hour with me. Stay connected with us on social media, on our YouTube, Instagram, LinkedIn. Clifton Ellis Johnson is me on LinkedIn. Tomorrow, again, come to our fundraiser. We're going to have fun. You get to work out. I'm running out of time, but I'm going to tell you about my challenge. Tomorrow, I'm going to post it out there on Instagram and Facebook Live, so you'll hear about it. But get geared up, right? It's about mindset and achieving your goals. So again, thank you to our sponsors, Comerica Bank, AE Media Group, and your generous donations. Go to our website, www.empowerseries.com. Find out what's going on. Click on donate, or you can text give or donate to 214-225-6337. Until then, I will see you at our next Empower Series event or tomorrow at Fitness 360. Have a good day.